You would think that bad business is one of the main reasons that business partnerships break up, but also bad partnership agreements are another very common reason. Going into business with a partner without the right agreement isn't just optimistic, it's bad business. Before you sign a partnership agreement that was drafted on a cocktail napkin, please watch this video. Can't tell you how common it is for business partners to walk into my office with a dispute that cannot be resolved and either no partnership agreement or just something that they wrote up themselves, leaving them in a situation where litigation is almost unavoidable. Here's 7 mistakes that I see all the time in partnership agreements that potentially could end up in a court and how to try to avoid them. I'm Dustin Lee. I'm the founding attorney of Ascend Legal Solutions. We're a business law firm based out of Houston, Texas. And today we're discussing partnership agreements. It's going to come down to a lot of things like, did you pick the right partner and did you clearly set expectations up front? But another huge factor is, do you have a partnership agreement in place? And does that partnership agreement actually cover the things that you and your partner have agreed upon? So in this video, as we dive in, you're going to see 7 real-world partnership agreement problems and what those look like in real life and potentially how to try to avoid those. Now, what we're going to talk about today, I'm going to say partnership agreement, and that's a very sort of loose term. So it may be that you are in a partnership, like a general partnership or a limited partnership, but also this could be referring to just your business partner in general. It may be within an LLC or a partnership agreement, may be called in your corporation, a bylaws, or in your LLC, an operating agreement or a company agreement. Or if you're a partnership, it may be called your partnership agreement. I'm going to say partnership agreement today, but just keep in mind that this really kind of applies to all those things. So mistake number 1, not defining roles, responsibilities, and how much work and when. The fastest way to create resentment and unhappiness in a partnership is to just assume that everybody knows who's doing what. So why do people make this mistake? Well, you go into the partnership thinking, well, we've talked about this or we've worked this out, we shook hands on it. But clearly, there's not always a meeting of the minds, or there's not always clear expectations set. A lot of times people think these roles that they have are very obvious, like I'm the money guy and he's the operations guy. But if it's not clearly documented and it's not formally agreed on, then later on down the road, it causes problems. And what happens here is as the business grows, problems tend to pop up if the partners haven't agreed on a specific authority or set of work. And then the other time that problems arise here is when nothing was really agreed to in writing, and then one partner sort of checks out, stops working, and just wants to sit back. And in a 50-50 split, undefined or unclear roles become a power struggle that often will end up in court. So what should a good partnership include? Well, this is not a complete list, but these are the things that you should be thinking about. Number 1 is authority, who has the authority to act for the business, sign contracts for the business, sign checks for the business. Then also, what are your roles? We're thinking things like operations, sales, finance, overseeing employees, client delivery. And each one of these roles needs to have enough specificity that we know who's going to be doing it, when, and how much. An agreement to contribute a certain amount of work. A lot of times the agreement will just say you're required to work here full time. But let's say both of you already have other businesses and you're coming together for a joint venture type of business. But then it becomes really unclear about how much work you're allowed to provide to this business versus how much you're allowed to work in your other businesses. And it needs to be clearly drafted and documented, because obviously if you have other businesses, you're not going to be devoting your full time to this business. And another good thing to think about is, how do we change roles and change processes as the business evolves, in case someone needs to take more of a role or less of a role in a particular area, or altogether with the business. A partnership agreement or operating agreement that doesn't talk about the roles of the partners and what work and when they're supposed to do, doesn't talk about authority, that's just a nightmare waiting to happen. How the partners are supposed to get paid from profits or wages or whatever it may be. You can think of a business partnership as being very similar to a marriage. Money is one of the number 1 reasons the business partnership gets tested, and that needs to be clearly spelled out in your partnership agreement. I can't tell you how many times I've seen people just do a handshake or, a cocktail napkin, 1-pager sort of thing. And they say, I'm the money guy, you're the sweat equity guy, we're going to be 50-50. And they just sign off on that. That's just extremely unclear about both the work side as well as the money side. It doesn't describe how much to put in money, or whether we can require someone to put in additional time. Things like that really are very important to the core agreement that is your partnership agreement. Now, I know details like this can feel premature or even uncomfortable at this point in the conversation, but I promise you they're not. If you can't talk about this stuff now, you're never going to be able to talk about it. And if talking about this stuff now causes problems, that's a huge red flag for the partnership in general. Now, look, I'm a big handshake guy. Your word is your bond. But these days, you really have to put everything that you can in writing. Numbers feel transactional, but a relationship is built on trust. To be totally honest with you here, if that trust can't be put down into a document where both parties sign, if one person says, no, you should just trust me, that's a huge red flag. If you can't sign a document that says it, that may not be trust. So what goes wrong here? Well, obviously, if there's no agreement at all, or if it's just, hey, you contribute a certain amount of money to start with, well, what happens when things go wrong? What happens when the business needs a little bit of liquidity, a little bit of cash? Can we require someone to put additional money in? Can we require them to loan the company some money? What happens if the business is about to go under? Same thing for the sweat equity, so to speak, the services involved in running the other half of the business. The same things apply there, but that's sort of what we already talked about. Profit distributions are another big topic that can create some issues between partners. So, for example, if one partner wants to keep all of the profits in the business to help grow and expand, and the other partner does not, that can create issues. In addition to that, if the business does hold those profits in, doesn't distribute, well, what happens to your tax situation? Because then you can have something called phantom income, where you're being allocated a share of the business's income that you now have to pay tax on, but the business hasn't actually given you the profits that would be allocated to you because the business intends to later reinvest those for further expansion. So now you're sitting here with a hefty tax bill that you have to pay and no profit distribution to cover it. Now, some partnership agreements or company agreements, operating agreements will require the company to distribute at least enough to cover your tax burden, but some do not. If you haven't had that conversation and you haven't written that into your agreement, you may end up with problems down the road. So what should your partnership agreement or operating agreement address? Well, this is not a complete list, of course, but these are some of the main ones. The capital contributions, who has to contribute and what and when, not only at the initial formation of the company, but capital in the future. Can we call capital? Can we require somebody to contribute additional capital? Having a clear profit and loss distribution formula set up to start with, and also determining whether or not the company has to distribute at least enough to cover tax burden is something that's really important to consider. This is a little more advanced, but you can even build in mechanisms that deal with adjustments, say if someone's not putting in the work hours that they're supposed to. And even if you don't address for adjustments, you may address for them being in breach of the partnership agreement or the operating agreement. So as you can tell, if your partnership agreement says nothing but, hey, we're 50-50, that's not a starting point for your business. That's a starting point for your lawsuit. Mistake number 3, no exit strategy. Now look, every partnership is going to end. The question is, did you plan for it in advance? If the partnership ends as a result of conflict versus whether or not the partnership ends as a result of the sale of the business, both of those things need to be addressed in your partnership agreement before you start. Now, nobody really wants to plan for one of those scenarios. Everybody likes to plan for the fun scenario where you exit the business together and make a lot of money. Some people don't even plan for that. What happens if we have a dispute? What happens if we don't get along and this thing doesn't work? And again, if you can't have that hard conversation up front, maybe you shouldn't go into business together. You don't want to look at a dispute resolution provision as a plan to fail or plan to have conflict, but these are things that need to be built in case something does happen so that your business and both partners don't end up in court later on, which I've seen bankrupt a business. What are the most common scenarios that cause problems here? Well, number one, if you get a 50-50 deadlock, obviously that's a huge problem. But there's other things that cause problems as well. What if one partner wants to stop working, but the other partner wants to keep on working? What happens in bankruptcy? All of these things need to be considered and built into your partnership agreement. So whether it be one of these more tragic life circumstances, or whether it be breach related or exit related for sale of the company, when you're making your partnership agreement, they need to be thought about up front and not later on down the line. So your agreement needs to consider all of these things. But in addition to that, when we ask these 5, 6, 7, 10 more questions come up, like business valuation. If we're going to be selling to a third party, how do we value the business? I die and my estate needs to sell the business. How do they value that portion of the business? And what happens with the buyout? Are there going to be any events that automatically trigger a buyout, like a bankruptcy or a divorce in the community property state? Also, we need to talk about timeline, payment terms, all of the other things that do end up in a buy-sell agreement that are really uncomfortable to talk about with your partner when you're going into something like this. So as you can see, a partnership agreement that doesn't deal with these things is like a loaded gun. You're just waiting to end up in court. And I will say, in my own personal practice, I have seen countless times situations like this where these things were not addressed in a partnership agreement. I've seen them end up in court or end up in a dispute that should have or could have gone to court. And then on the flip side, I've had people come into my office, have these hard conversations, and realize, hey, this probably isn't for us. And that's okay, because in that situation, we probably saved you a whole lot of money and headaches down the road. Mistake number 4, ignoring dispute resolution. The time to get together with your partner and agree on how disputes are going to work is now, not after the dispute arises. Because once that dispute arises, you're not going to be able to agree on anything. This is the big one, y'all. This is the one that gets your business ending up in court, going bankrupt, paying attorney's fees, potentially even getting a court-appointed receiver over the business that's going to run the business and take it away from the partners until they can come up with a resolution or until the lawsuit has concluded. And that receiver, guess who pays that receiver? The business does, out of the money that you would have been entitled to if you didn't have this dispute in the first place. Now, why do partners make this mistake of not thinking about dispute resolution before a problem comes up? It's because everybody's excited and happy and optimistic at the beginning of the relationship, and we're not thinking about what could happen if things go wrong. You're going into something like this excited, ready to make some money, and you're not thinking about dispute resolution if you fail to make money, or if you do make money but there's a deadlock on how to handle that. Again, this is not a trust issue. Because just because you want to put something down on a piece of paper doesn't mean you don't trust one another. It means that you want the expectations on both sides to be super clear. So what goes wrong here, especially in a 50-50 where you've got a deadlock situation, the only way to resolve that deadlock is to end up in court. Unless you build in a dispute resolution mechanism to your partnership agreement or your operating agreement, you're putting this in the hands of the judge or the jury to sort out. And that's never where you want to be. So what are some options for working something like this out? Well, obviously, you can have a dispute resolution protocol to go through, like first a notice and an informal negotiation from both sides. You could even send it to a tribunal of trusted business advisors to help weigh in and come to an agreement. You could submit it to a mediation before you move forward, and then ultimately you can decide whether you want this to end up in arbitration or litigation if it comes to that point. In 50-50 situations, you could create some sort of tiebreaker, either an actual written-in tiebreaker or a business advisor that you trust to make decisions for your business that's not a part of your business to make the tiebreaker vote. Now, it's a little dangerous, and I don't always recommend it, but some people like that because it keeps the situation out of court. Ultimately, you need clarity and predictability on how disputes about this business are going to be resolved and the process to go through those things to get them resolved. Because at the end of the day, if you don't have a dispute resolution mechanism or procedure built into your partnership or operating agreement, it's going to end up in court and it's going to be very costly for you. Mistake number 5, no clear decision-making authority. This kind of ties into a couple of the others that we've talked about, but especially in a 50-50 situation, you've got a framework where potentially either one of these people or both of them could be making decisions for the business in conjunction with one another or individually. And if that's not all worked out and spelled out clearly in advance, you may have a situation where your partner is doing something that you think they're not supposed to do. So for example, if you think that both partners need to agree on every major business decision, you need to write that into your agreement, because you may have one partner go out and make major business decisions without the input of the other partner because they are assigned a management role in the business. They're either a manager or a general partner or a director or an officer like a president, and they have the authority on paper to make decisions for that business on behalf of that business, sign contracts or checks for that business. And if they do, and if there's no limitations built in on that or no voting mechanism built in on that, then potentially you could have one partner doing something that the other partner does not approve of. And then on the flip side, if you've got the 50-50 deadlock, now you've got key decisions not being made for the business because there's a deadlock. We're talking about hiring key, critical, high-ticket employees. We're talking about business financing, capital investment, strategic pivots, things like that get deadlocked because there's no clear authority or dispute resolution procedure built in. And in unequal splits, like a 70-30, the minority partner, the 30, can sometimes feel steamrolled, like they don't get a voice in the business, like they're not actually getting to participate in the business. And sometimes you even have the majority partner breaching their fiduciary duty to the business or to the minority partner. So what should a proper partnership agreement or operating agreement contain? And again, this is not an exhaustive list. There's lots of things that should be in there, but for these purposes, a few things that you should be thinking about. Number 1, who has the authority to make minor business decisions? who has authority to make day-to-day business decisions, who has the authority to make major business decisions, and when do those things have to go to a vote? If there is a vote and it's 50-50, how do we deal with deadlocks? What is going to require a unanimous consent that everyone has to sign off on? So when decision-making authority isn't actually written down in the agreement, it can lead to big problems. Mistake number 6 is not addressing future changes or the potential for future changes to the business. So think about it like this. The agreement that you sign on day one not only has to cover the business as it exists on day one, but has to cover the business as it exists for years to come. Now, obviously, you can amend these agreements later on, but you want to build in as much of that on the front end as possible to avoid disputes and conflict later on. Now, again, this is something that's going to feel weird, awkward. It's speculative to start with because you have not decided exactly what's going to be happening with this business. You don't know how well the business is going to do. So it's hard to plan for all that when you're drafting your original partnership or operating agreement. Updating the agreement later can always happen if everybody's on board. The problem that happens is later, maybe your partners are not aligned anymore on their vision for this business, and now it's incredibly difficult to get any changes made to the agreement. So what are we talking about here? We're talking about, number one, adding new partners. What happens if we want to issue new interest to a new partner or sell to a new partner? Then also, what happens if we want to expand? What happens if one partner wants to expand and the other person is just happy with where we're at? What should the agreement address? Well, number one, it needs to address the amendment process for the actual agreement, because it is, if the partners are aligned, it is great to go back and change this agreement from time to time to meet the current vision and goals for the business. You need a defined process for admitting new members or new partners in case you want to add somebody new, and whether or not that's going to happen through a new issuance or whether it's going to happen from the existing partners selling part of their interest in the business. You need to build in provisions for making strategic major changes to the business. And then in addition to that, it's always nice to build in a review schedule for one of these things, to revisit your partnership agreement from time to time to make sure everything is currently aligned with both of your partners' vision for the business as well as the state that the business is in. So what you're going to have to do is you're going to have to assume that the partnership agreement that you're making today is going to cover your business for many years to come, and you need to account for as much as possible in that agreement. Mistake number 7, and I'm going to sound like a broken record here, not having your partnership agreement either drafted by or at least reviewed by an attorney. The partnership agreement or operating agreement is the absolute most critical document that you've got in your business formation, and if you're not getting it reviewed by an attorney, you're really asking for trouble on down the road. So this is one I actually see all the time. Either no partnership agreement at all, or it's written on a cocktail napkin, or it's a DIY template that you found on the internet that doesn't know anything about your agreement with your partner or your actual business. Why do people make this mistake? Because sometimes if you're bootstrapping it to start with, I understand. It's difficult to come up with the cash to pay an attorney to get something like this professionally handled for you. But let me tell you, it's going to be 10, 20, 50 times more expensive to deal with this stuff in a lawsuit down the road versus hiring an attorney to do it right the first time, or at least review it and let you know where the problems are sitting. And I understand legal fees, they feel unnecessary and burdensome when the business isn't even making any money yet. But I promise you, if your business gets to the point of making money and problems arise, it's going to cost you a fortune. What is an attorney going to do for you in a situation like this? Well, ideally, the attorney is going to draft you a very professional and comprehensive partnership agreement, or if you're having an attorney review it, he's going to point out all of the issues, the problems, the inconsistencies, the vagueness, ambiguity, and the issues that were not addressed in the agreement and what needs to be put in there. Give you some deal points, talking points, or potentially even let you know that this agreement is so bad that you need the attorney to fix it for you. Please. It sounds very cliche. An attorney is telling you to get an attorney, but the job of an attorney is to help you manage risk and is to help to keep you safe. Good attorneys are always going to tell you to get an attorney. We know that sometimes it's hard. We know that sometimes you're bootstrapping it, and legal fees seem counterproductive when you're starting a business, but I promise you they are not. So I very strongly encourage you, if you're entering into a partnership with someone, get a qualified business law attorney in your jurisdiction to either draft or at least look at the partnership agreement, because the cost of getting a partnership agreement right on the front end is just a tiny fraction of the cost of getting it wrong in a lawsuit down the road. So today we covered 7 mistakes that I see commonly pop up in partnership agreements in my practice. This is certainly not, the full list of mistakes and issues that we see, but these are some of the most common ones. And so you'll have those in mind when you're talking about your partnership agreement with your partner. And if you think your partnership agreement is very, very important, well, how you structure a transaction when you and your partner are actually buying into a business as opposed to starting a fresh business is equally important. And we have another video about that you can check out. Thank you all for watching.